Thinking like, yes,
That's usually what happens, isn't
that's what I heard too.
it? Thank you so much. Okay, now you're all done with me.
Okay,
You are off to, who's responsible?
I'll take it.
You. Oh, you have to go,
Yeah.
okay, so we're set.
Okay.
If you all done everything you need to do here.
Would you be willing to take a picture?
Oh, I left my phone in my office.
Okay.
If you want us to send you one.
Would you please, yep,
It's fast.
it does fine, yep, that's fine with that. Is this still, if you want somewhere else? It's up to her. Where me and you. Oh, better than me.
Yeah, let's do it.
You know what, there's a good point.
Thank you.
You're welcome.
Oh, yeah. Thank you. No, are you gonna get into?
Oh, yes, ma'am.
Yeah, you get what you pay for though. The judge and the photographer. You get what you pay for though. Alright, hold on. Current situation here. Are we good?
Good.
We'll take a couple. Oh, look at those smiles. Aww. Last one. Okay. Wonderful.
Yeah.
Thank you.
OT for me.
So who would I get to send you this one? I can send you.
Yeah, I can see that.
She's the best person.
Yeah.
Yeah.
You should go there.
Send it to your phone? Send it to- I try to take pictures of all my writing rooms, and I make the little signs, and not that we were today's wedding, so. I think we're done in time for my 9 o'clock jacket. So.
Awesome.
I know. I wish today kind of day.
It's an easy day.
Hamilton, so.
Oh, okay.
Short 30 days, he's not bad at all.
Take it easy, I'll be fine.
I do. Oh, wonderful, thank you so much.
Yes.
You all enjoy the rest of
Thank
your
you so much.
day. Thank you.
Absolutely. Thank you.
Thank you.
Hey, God bless.
Cheers and everything. You're so welcome.
Sorry, Mama, I didn't see you.
I'm gonna have 15 years, I thought.
Thank you.
Oh, I forgot.
Will do.
Jeremiah. Jeremiah, is for you and that. Thank you. Those are those are, yep.
Thank you.
A little break from the mundane, right? I was looking to see if anybody's logged on yet.
go on line 481, please? That gentleman's here to see it. Okay, thank you.
Morning, EPA. Good morning.
Hi there. I just sent you a chat. You should be in Judge Green's courtroom.
Oh, okay, thank you.
You're welcome.
All right, I'll let Barry.
Good morning, Mr. Hitchcock.
Good morning.
How are you?
I'm well. Yourself?
I'm good, thank you. I made you co-host and there are some people in your waiting room, so if you want to pull them into your meeting room, that's great.
Okay.
Thank you.
How do I get into my room?
I made you co-host. If you open up the breakout rooms.
More? Okay. I
Yeah.
see it now.
Yep.
Okay. Thank you.
Yeah, you're welcome.
hate all these okays. It's like, we know that, we know that.
Good morning.
Good morning, Miss Watt.
I'm trying to find out if I'm in the correct courtroom.
No, if it's for a felony matter, you should be with Judge Green.
Okay, you don't happen to have that Zoom number. This is the one they gave me at assigned counsel.
Yes, I do. It's 933
933
057
057
8570.
8570. Thank you so much.
You're welcome.
Hello, this is Ian Babicki. I just want to make sure I'm in the right room.
Ian, I see you at 9 o'clock today, so you are in the right room.
Okay, thank you so much.
You're welcome.
We're going back to the main session. Okay.
Apologies for the interruption, sir. Have you spoken to the defendants that are in your waiting room yet?
I spoke with Babiki. I think I need to speak with some others here. I was just talking to our property
I'm gonna
manager.
pull them out. Let's figure out what's going on. This
Okay.
is 2404435 LT Trilogy Residences versus Ian Babicki and Robert Babicki. Have your appearances, please.
I'm here, man.
Yes, Your Honor, Clifton Hitchcock, Swiss Stack Levine on behalf of Plaintiff Trilogy Residences.
Mr.
Hello?
Babicki, your name for the record, sir.
Ian Babicki, ma'am.
And do you know where Robert Babicki is?
Yeah, he's not here. He's working.
I'm sorry?
He's working. He's not here.
He's at work, okay. And last time we were here, you met with Lakeshore Legal Aid. Are they representing you today, sir?
No.
Okay.
Your Honor, if
It's a
I may,
non-payment of, Go ahead, sir.
The parties have agreed to the terms of a consent judgment of possession only, rather Ian Babicki and Trilogy have. And with your honor's permission, I state those for the record.
Yes, please.
Okay. There's rent to retain possession in the amount of $2,908.14. Costs in the amount of $243.71 for a total amount of $3,151.85, which the defendant, Mr. Ian Babicki, must pay in full or move out on or before August 5th, 2024, or the writ may issue thereafter. I've explained Michigan Court Rule 4.201J to him in his 3-day right of rescission as he's unrepresented by counsel. Should there be anything he doesn't fully understand about the judgment that he is entering into today and has authorized me to sign on his behalf and submit to the court, or that he has other good reason to bring a motion to the court to set aside the judgment within 3 court days of entry of the judgment. So this, your honor, would operate as a consent judgment as to Mr. Ian Babicki and a default judgment at the same terms as to defendant Robert Babicki.
Mr. Babicki, you were present back on July the 10th when there was a video played that explained the legal rights you have available in the landlord-tenant case.
Yes, ma'am.
You have any questions about those rights?
Nope, just need to take care of this, the stuff I need to take care of, ma'am.
Do you have any questions about today's proceedings?
No, I just wanted I already asked the guy that just spoke for me, the attorney. I just wanted to make sure, is there a way I could pick up the paperwork like tomorrow so I could get this sent into like rental assistance?
I can't guarantee that because once he sends it, I will sign it. But if he doesn't send it today, then it won't be signed. So it's kind of
Well, I'll
typically
submit
goes
it.
in the mail.
I'll submit it by my file. I suggested maybe he call the court in the morning and see if they have a copy before he comes to the court for it. But
Are there any other questions, Mr. Babicki?
No, ma'am.
And sir, you're free to go. You have a good day.
Thank you. You as well.
Thank you. 2404309 LT. This is West Village Estates versus Irma Dixon Ward.
your honor, Clifton Hitchcock, Swiss Stack Levine on behalf of West Village Estates.
Ms. Dixon Ward.
Oh, yes, I'm here.
Good morning, ma'am. The last time we were here, you indicated that you had made an application for rental assistance. The court has not received a DC 539 from you. What's the status of your request for rental assistance?
I came in to bring that slip, and the court clerk told me that I had till the next day because I had been sick. Well, anyway, when I came in the next day with the copies that I already had, she said it was too late. But I don't know what they're doing, but I will pay my own rent by the 31st. I'm filing an appeal because they told me to do what I did. Then they were supposed to help with June, and I'm not going into a 3rd month. So I'll have my rent paid by the 31st.
Mr. Hitchcock, what is the rent to retain possession?
Rent to retain, your honor, is $1,564.82. Costs in the amount of $187.68 for a total amount of $1,752.50. So, Ms. Dixon Ward, if you're agreeable to paying that amount, you agree to that amount, and you believe you can pay it by the 31st, I'd ask if you would agree to a consent judgment to pay that amount or move out on or before August 5th, 2024. And if you didn't do either of those things by that date, then after that date, your landlord could apply to the court for an order of eviction. Would that be agreeable to you?
Yes, I'll have it done before then.
Okay, and I because you're not represented by
No. Ms. Dixon, you were present back on July the 10th when there was a video played that explained the legal rights you have available to you this morning, correct?
Correct.
Do you have any questions about that video?
No, I do not.
Do you have any questions about your rights?
No, I do not.
Ma'am, was the amount of rent that Mr. Hitchcock indicated, $1,564.82, the accurate amount of past due rent?
I believe so. When last I checked, it was something like that.
175.
Ma'am,
Yep.
17. Say it again, sir.
1,007.
no, Mr. Hitchcock.
Sorry. Yes.
Ms. Dixon Ward, the rent is $1,564.82. So my question to you was is that the correct amount of rent? And you said yes, correct?
Yes, I believe so.
And then the cost requested by the plaintiff's office is $187.68, which is a total of $1,752.50.
Okay. That's
So
good.
ma'am, my question was, what I was starting to say before was, in as much as you admit and agree that that is the amount of past due rent and plaintiff is entitled to cost, there is not a tribal issue of fact, and the plaintiff is entitled to entry of judgment in the amount requested. And Mr. Hitchcock's office will prepare a judgment submitted to the court that has that total and indicates that you have until August 5th to either pay that amount or vacate the property.
Okay.
Okay, Mr. Hitchcock's office will submit that judgment to the court. I will sign it and a copy will be mailed to you at the address we have on record, okay?
All right. Thank you.
Submission
Thank
as
you. Have a good day.
Submission as a consent judgment, Your Honor, correct? Versus judgment after hearing, or just the matter of form
After hearing.
after hearing? Oh, that's okay. Just want to make sure. Thank you.
Mr. Berncrant, you want to get moved into would you like to be moved into a breakout room with your tenants?
Yes, please, Your Honor. There was one case scheduled for 9:15, which was 4405, but she may not have checked in. But please do put me in the breakout room and I'll take care of everything. Thank you.
Including Ms. Washington from the 9:15.
Perfect. Thank you so much, Your Honor.
Mr.
Thank
Berncrant, you are co-host. You can move around.
Okay, perfect. Appreciate it.
2404320 LT West Village Estates versus Jessica Kimbrough.
Your Honor, Clifton Hitchcock on behalf of West Village Estates.
Ma'am, state your name for me, please.
Jessica Kimbrough.
Ma'am, the last time we were here on July the 10th, you indicated you made an application for rental assistance and this court directed you to file the DC 539. Did you file that with the court?
Yes.
When did you file that, ma'am?
Let's see, on the 10th, 11th, 12th.
What's the status of your application for rental assistance?
My application has been denied.
It's been denied?
Yes.
Thank you. Mr. Hitchcock, what is the rent to retain possession?
Your Honor, rent to retain is $2,949.15. Costs of $187.68 for a total redemptive amount of $3,136.83.
Ms. Kimbrough, is the amount of rent claim due and owing by Mr. Hitchcock accurate, the rent being $2,949.15?
Yes.
You understand the plaintiff is requesting costs of $187.68 for a total judgment of $3,136.83.
Yes.
And ma'am, you were present back on July 10th when the video played that explained the rights you have available to you in this landlord-tenant matter. Do you have any questions about that video?
No.
Do you have any questions about today's proceedings?
No.
Ma'am, in as much as you admit and agree that the amount of rent claim due and owing is accurate, there is not a tribal issue of fact and plaintiff is entitled to entry of judgment in that amount. Mr. Hitchcock's office will prepare a judgment that indicates that total $3,136.83 is due and owing. After hearing, you will pay this amount or vacate the property by August 5th. He will submit the paperwork to the court. I will sign it and a copy will be mailed to you at the address we have on record. Do you have any questions, Ms. Kimbrough?
No.
Then ma'am, you're free to go. That concludes this matter. You have a great afternoon.
You too. Thank you.
Thank you. 2404325 LT West Village Estates versus Tanisha Stamps. Ms. Stamps, turn your video on, unmute yourself and state your name for me, please.
Tanisha Stamps.
Ms. Stamps, the last time we were here on July 10th, 2024, you went into a breakout room to meet with Lakeshore Legal Aid. Are they representing you in this matter?
No, they're not.
Mr. Hitchcock, what is the rent to retain possession?
Rent to retain is $1,588.95. Cost of $187.68. Total redemptive amount of $1,776.63.
Thank you. Ms. Stamps, is the amount of rent indicated accurate? $1,588.95.
I'm not certain. I was supposed I hadn't checked it. What was the total?
Okay,
Can I have the, I'm sorry.
The total is $1,776.63. That is the $1,588.95 plus $187.68 in court costs. Since you're not sure about the amount, we'll get you moved back into a breakout room. Mr. Hitchcock will be there momentarily.
Thank you.
Thank you. 2404329 LT West Village Estates versus Sean Washington and Lakeisha Washington.
Your Honor, John C. Hitchcock on behalf of West Village Estates.
State your names for me, please.
Sean and Lakeisha Washington.
You take it off mute.
Yeah.
Thank you. Last time we were here, you went into a breakout room with Lakeshore Legal Aid. Are they representing you this morning?
No, there was no help.
Oh, Mr. Hitchcock, what is the rent to retain possession, sir?
Rent to retain is $3,111.29. Costs of $241.71. Total redemptive amount of $3,353.
Were you able to hear the amount of rent claim due and owing is $3,111.29?
Yes.
Is that the correct amount of rent?
Yes.
Plaintiff is also entitled to recover the cost in this matter, $241.71 for a total judgment of $3,353. You were present back on July 10th when the court played the video that explained the rights you have available to you in this landlord-tenant matter?
Yes.
Do you have any questions about those rights?
Yes, I wasn't present at that time, so can I hear him again?
Absolutely. Give me one moment. Why weren't you present?
I was at work. I couldn't get off that day, but I had to take off the day.
But I was here. I heard right.
She was here, but I didn't get
I know
there.
you were because I made a note. I make notes of who's here and who wasn't here, and I'm just always curious when there's a landlord-tenant case and a person is not present. And that's okay. And Mr. Washington, you have the right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be for your area. If you look on your screen, there is a Lakeshore Legal Aid attorney who is checked in with their 1-800-888-783-8190 number. You have the right to have your case heard in the county or district where the property or any part of it is located. If you look at item number 3 on the summons that you were served, if your landlord has checked the box saying that the case is not being brought where the premises is located, you may ask the court to transfer the case to the county or district where the property or any part of it is. You may ask the court to move the case by filing a request or motion in writing before the court date listed on the summons, or ask the court in person at the first court hearing. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use Form MC22 jury demand and file it with the court. You must pay a fee of $50 when you make your jury demand or within 5 days of the court explaining your right to a jury trial. You do not have to pay the fee if you have asked the court to waive fees and the court has approved your request under Michigan Court Rule 2.002. Your landlord has asked for you to be evicted from a residential property because you haven't paid rent. You may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or a federal help for homeless veterans program. You should have received this information on local rental and housing assistance with the summons that you received and were served in this matter. You do not need a judgment against you to receive help from the places just listed. A copy of the summons and complaint from your case are enough. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You can find a program at courts.mi.gov/CDRP. You may be able to reach an agreement with the landlord that will mean the case gets dismissed. The court must provide you with a form for this or tell you how to find it online. Mr. Washington, this court has now read your rights. Do you have any questions about those rights, sir?
Yes, so if,
However, the court is noticing that there,
I'm sorry.
What's your question?
Yes, can I dispute it? Would that give me more time?
Are you disputing that
Am I
there is
saying it right?
$3,111.29 in rent due and owing?
How much it is?
And it's the court costs added on to that. That's how much.
The court costs are $241.71. Mr. Washington, are you disputing the amount?
She said no.
She
No.
said no?
I mean,
Okay.
she's adding it up because I wasn't adding it all up.
Sir, in as much as you
Sure.
admit and agree that the amount of rent claimed due and owing is accurate, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment in that amount. Mr. Hitchcock has placed the total on the record as $3,353. That is the past due rent and the court costs. You must pay this amount or vacate the property by August 5th. Mr. Hitchcock will prepare a judgment that indicates this amount and file it with the court. I will sign it and a copy will be mailed to you at the address we have on record. Ms. Washington, do you have any questions?
No.
Mr. Washington, do you have any questions?
No.
Are you sure?
Yes, ma'am.
That concludes this matter. You're free to go. You have a great day.
You do the same.
Thank you. 2404319 LT West Village Estates versus Kayla Johnson.
Your Honor, Clifton Hitchcock on behalf of West Village Estates.
Mr. Hitchcock, this case was adjourned on July 10th because the defendant was not available. Mr. Lee was present. It appears that he is here again. Mr. Lee,
Yes, ma'am.
how may I help you this morning, sir?
All right. I talked to Renee yesterday, and I was just wanted to talk to the lawyer before I discuss anything over with you.
You want to talk to?
I want to talk
You want
to
to
the
talk to
lawyer.
Mr. Hitchcock?
Yes, ma'am. I would like
Okay,
to
we'll
go
get you
in the
moved
room
into a
with him one-on-one.
breakout. We'll get you moved into a breakout room, sir. He'll be there momentarily. Let me call the rest of the 915 cases.
Oh, that's fine. Thank you so much.
Thank you. 2404448 LT Trilogy versus Christine Shalda.
Your Honor, Clifton Hitchcock, Swiss Stack Levine on behalf of Trilogy.
Good morning, ma'am.
State your name for me, please.
Christine Shelda.
Ms. Shalda, the last time we were here, you indicated that you filed for rental assistance and you asked to speak to Lakeshore Legal Aid. Is Lakeshore Legal Aid representing you today?
Nope, they denied me.
And ma'am, the court directed that you file the DC 539, which indicates that you made an application for rental assistance. What's the status of your application for rental assistance, ma'am?
I was also denied, but I will put in for an appeal.
Mr.
I think we
Hitchcock,
should-
what is the rent to retain possession?
Your Honor, rent to retain possession is $3,053.91. Costs in the amount of $187.68 for a total redemptive amount of $3,241.59.
Thank you. Ma'am, is the amount of rent $3,053.91 correct?
Yes.
Ma'am, the plaintiff is also entitled to recover costs in this matter of $187.68, which will be a total judgment amount of $3,241.59. When we were here back on July 10th, the court played a video that explained the legal rights you had available to you this morning. Do you have any questions about those rights?
I do not.
Do you have any questions about today's proceedings?
I do not.
Ma'am, inasmuch as you admit and agree that the amount of rent claim due and owing by the plaintiff is correct, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment. Mr. Hitchcock's office will prepare a judgment after hearing that indicates the past due rent and the cost for a total of $3,241.59, and will further indicate that you must pay this amount or vacate the property by August 5th, 2024. I will sign that, and a copy will be mailed to you at the address we have on record. Do you have any questions this morning?
I do not, ma'am.
Then, ma'am, that concludes this matter. You're free to go. You have a great day.
Thank you, you as well.
Thank you. 2404439 Trilogy versus Richard Boyd and Brianna Cooper.
Hi,
Your Honor, Clifton Hitchcock on behalf of Trilogy.
Ms. Cooper, do you know where Mr. Boyd is?
he's currently at work. He couldn't get off.
And the last time we were here, you met with a representative from Lakeshore Legal Aid. Is Lakeshore Legal Aid representing you today?
No, they denied me.
Mr. Hitchcock, what is the rent to retain possession?
$2,882.74, costs of $243.71 for a total of $3,126.45.
Ms. Cooper, is there $2,882.74 in past due rent?
Yes,
Ma'am, the plaintiff is entitled to the court cost of $243.71 for a total judgment of $3,126.45. You were present back on July 10th when the court played the video. They explained the rights you had available this morning. Do you have any questions about those rights?
no,
Do you have any questions about today's proceedings?
no,
Ma'am, inasmuch as you admit and agree that the amount of rent claim due and owing is accurate, there is not a triable issue of fact, and the plaintiff is entitled to entry of judgment. Mr. Hitchcock's office will prepare a judgment after hearing that indicates that total of $3,126.45. You must pay that amount or vacate the property by August 5th, 2024. Once he submits that paperwork, I will sign it and a copy will be mailed to you at the address we have on record. If there's nothing else and you have no questions, that concludes this matter and you're free to go.
thank you.
Thank you. I'll see you after you speak with those people, Mr. Hitchcock.
Thank you, Your Honor.
Good morning, Mr. McCausland.
I did not present her with a
Ms. Turner?
Yes.
This is 2404333 Willow Glen versus Turner. Ma'am, the last time we were here, you indicated that you made an application for rental assistance and you met with Lakeshore Legal Aid. Is Lakeshore Legal Aid representing you today?
I never met with, what is Lakeshore Legal Aid? I did rental assistance. This is my application through DHS.
Okay, was that approved?
They haven't said anything back yet. I did it on I did it on the 12th. It says it here. And they haven't said anything back to me yet. And I actually went in the office.
I'm sorry, go ahead, ma'am.
And I actually went into the office to ask them about it yesterday, and they said somebody will reach out. I should have something in the mail as soon as possible. So I checked my mail this morning. Well, the mail haven't ran yet, but I checked it. It still ain't nothing in there yet. So I don't know what to say about that.
Mr. McCausland, would you like to go into a breakout room with Ms. Turner?
Sure. My client is here too, Willow Glen.
We'll get you, see, Farine, we'll get you moved into a breakout room together.
Thank you.
Thank you. It's a recall of 2404325 West Village Estates versus Tanisha Stamps. The parties have had the opportunity to speak. Mr. Hitchcock, how are we proceeding?
We have, Your Honor. I think Ms. Stamps better understands how the figures have been arrived at, and again, the rent to retain possession is $1,588.95, costs in the amount of $187.68 for a total redemptive amount of $1,776.63, which Ms. Stamps must pay in full or move out on or before August 5th, 2024. The writ may issue thereafter. So plaintiff seeks a judgment in that amount at this term.
Ms. Stamps,
Yes,
was that your understanding and agreement with Mr. Hitchcock?
yes.
And ma'am, you were present when the video played on July the 10th. Do you have any questions about the rights available to you in this case?
I don't have any, I don't.
Do you have any questions about these proceedings?
No, I do not.
Mr. Hitchcock, is this being filed as a consent judgment?
Well, I can ask Ms. Stamps, do you consent to the terms of this judgment that I've just stated? Do you agree to them? May I sign this judgment on your behalf and submit it to the court with your signature? Yes?
I'm sorry?
May I sign this judgment with your permission? May I sign your name to it as we're not together today? May I sign your name to this judgment and submit it to the court?
That's fine.
Okay, that's a yes. Okay. Then yes, Your Honor, it would be a consent judgment. Ms. Stamps, as Your Honor, represented by counsel under the court rule MCR 4.201J. If there is anything you don't fully understand about the judgment that you're entering into today and authorizing me to sign and submit to the court, or that you have other good reason, you can bring a motion to the court within 3 days of entry of the judgment by the court to set aside this judgment. Do you understand that?
I do.
Thank you. Okay, I'm satisfied,
any-
Your Honor. I'll submit a consent judgment to that effect today.
Ms. Stamps, do you have any questions?
I don't.
Then, ma'am, he will submit that, he will file that consent judgment with the court. I will sign it and a copy will be mailed to you at the address we have on record. Have a great day.
You too.
Thank you. So recall of 2404333 LT Willow Glen versus Rashina Turner. Mr. McCausland, you've returned from the breakout. How are we proceeding?
We had a good meeting and Ms. Turner has agreed to a consent judgment and she's given me.
Your Honor, I apologize. Did you call East Village? I apologize. Oh,
I did. Your cases are the only cases left on the docket.
okay. Well,
No, I called Willow Glen versus Turner.
I know. I'm sorry, Your Honor.
No
Okay.
worries.
I'm juggling today. Yes, sure. Just mute.
Okay, yes, we met and she's consented to the entry of a.
I'm sorry, Mr. McCausland.
Yes,
I'm looking for her.
I think I gave her the wrong instruction.
She's in with our clerks.
Okay, right.
Ms. Turner, Mr. McCausland was putting the terms of your agreement on the record.
Okay, Ms. Turner and I met in a breakout room. We've agreed that the amount due through July is $1,999.93. The allowable court costs are $191.93 for a total judgment amount of $2,151.86. I've informed her about the 3-day rule that allows her to ask the court to set it aside if there's any evidence that I've tricked her or taken advantage of her. And she's given me her consent to sign her name to this judgment, which I will e-file with the court. And I promise that I will give her, when I e-file it with the court, I will also email it to Ms. Turner so that she can have a copy to show DH her assistance program and they can confirm up the amount.
Ms. Turner, you were present back on July 10th when the video played that explained the rights you had available to you this morning.
Yeah, yes.
Do you have any questions about those rights?
No, ma'am.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then Mr. McCausland's office will file that document electronically. I will sign it and a copy will be mailed to you at the address we have. If there's nothing else, Ms. Turner, you're free to go. You have a great day.
You too, ma'am.
Thank
you,
you.
Your Honor. Have a nice day.
You too. Mr. Cliff Hitchcock, were you done speaking with Mr. Lee? You're muted, sir. Let's try something else then. 2404338 LT, the Maxwell versus Angelina Rivera.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
State your name, ma'am.
Angelina Rivera.
Ms. Rivera, when we were here back on July 10th, you went in to speak with Lakeshore Legal Aid. Will they be representing you today?
No.
How are we proceeding, Mr. Katz?
Your Honor, I did have an opportunity to speak with Ms. Rivera. Currently, there's a non-payment rent possession case. Currently, there's a balance due of $1,854. Ms. Rivera understands that she has until August 5th to pay that amount. She was advised of MCR 4.201, and she did authorize me to submit this to the court with her verbal authority.
Was that an accurate statement of your agreement, ma'am?
Yes.
And you have no questions about the rights available to you today?
No, I just wanted to make sure if I'm able to get a written consent from the property manager to give me an extra 30 days that I can submit that to you guys.
Say that again for me.
So after the previous court date, I had went and talked to the property manager and he told me to file a motion to get an extra 30 days. But the gentleman that I just spoke to, he said that he wouldn't be able to do that, that I would have to get a written consent and send it to you guys.
Your Honor, I did not mention that she has to get that sent to the court. I said if my client is willing to work something out and give her more time, then that's up to them and they can do that. However, I indicated that it's best if she got that in writing. I don't think any written agreement between her and my client are necessary to submit to the court. That should take precedence if in fact my client decides to renege on any agreements that are in writing.
Did you understand that, Ms. Rivera?
Yes.
Mr. Katz will file a judgment with the court that indicates $1,854 is due, and you will pay this amount or vacate by August the 5th. If you have not vacated the property, they can come back, they being the plaintiff, can come back and file a request for the court to sign an order that will physically remove you from the property. What Mr. Katz is saying is that if you reach a different agreement regarding the amount of time with the landlord, get it in writing.
Okay.
Someone telling you you have 30 more days is not sufficient. You need to document if there's something other, if there's some agreement other than the judgment that is filed with the court, okay?
Okay, that sounds good.
Anything else, Ms. Rivera?
No, that's it, ma'am.
That concludes this matter. You're free to go. You have a great day.
Thank you.
Thank you. 2404346 T Maxwell versus Emilio Hart. State your name for me, please.
DeMilo Hart.
DeMilo Hart. Mr. Hart, the last time we were here, you indicated that you made an application for rental assistance and you would be speaking with Lakeshore Legal Aid. Is Lakeshore Legal Aid representing you today, sir?
No, but I had spoke to them, but they never reached out back to me. They reached out, but they ain't say nothing else after that when they reached out.
Sir, what is the status of your application for rental assistance?
I don't think it went through, but he said they was working on, my caseworker said they was working on it. So I had sent the documents and stuff in, and then I had ended up, so I don't know if they called back because I had went to jail last week. So I'm on a whole tether now, so I don't know what's going on. So I'm trying to figure everything out because when I'm on tether, they got me to this address, and it's the only address I got. I can't use nobody else's address. So I just got out yesterday.
Mr. Hart, did you speak to Mr. Cass this morning?
Yes, and I was trying to explain that to him. Like, this the only
about
address.
The tether.
Yes, that's why I was just talking to him. This the only address I can use to stay here or to be on tether. I can't use no other address.
Mr. Katz?
Your Honor, I'm not sure how that relates to his requirement to continue to pay rent. I'm sorry, I'm in another court and I've got spotty reception, but I understand that he just got out of jail, but I don't think that requires that my client has to provide him any more time. I did tell him that if they want to work with him, they can do that just like I indicated on the prior one.
That being the case, Mr. Katz, what is the rent to retain possession?
Your Honor, there's $2,141 of past due rent, $170 of costs for a total of $2,311. Mr. Hart would have until August 5th to pay that amount. He was advised of MCR 4.201 as I indicated, if my client is willing to give him more time, that should be in writing if they do come to some kind of agreement.
So, Mr. Hart, you were present back on July 10th when the video played that explained the legal rights you had available to you in this landlord-tenant case. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about the consent judgment?
No, not for, well, I do, but it ain't gonna matter because the way my tether set up, I could barely go place. I can only go to work right now. That's why I'm trying to talk to the officer who gave me the tether. Well, I got it from 34, but I'm trying to talk to him and see if I can get out early or like how late I can return home because I'll be having to go do stuff.
I'm sorry. So I'm sorry, Mr. Hart, you have a criminal case in 34th?
Yes, I just got it. That's what I'm saying.
Mr. Hart, and the tether is keeping you from being able to work?
Yeah, it's keeping me at work because my work, certain job that I got to go to, they is a certain limit. So he gave me 7 to some other time, but I normally go to work at 6 o'clock in the morning.
Okay, Mr. Hart, these are two separate things. If you have an agreement with Mr. Katz, he will sign it and submit it to the court. I'll sign it and a copy will be mailed to you. if you're saying that you're on tether and there's something about your tether restrictions in a completely unrelated case that you need to address, you need to submit that in writing, your work hours in writing to the court.
Yeah, that's not what I'm saying.
If you have an attorney, sir, I'm gonna ask you not to say anything about the criminal case, because if you're represented in that case, I don't want to do anything, make a record that would impact you.
Oh, no,
Okay.
it's not. No, I was just saying I couldn't probably work like the way my schedule is, because when I get time to need to get the more money, that's why I'm just saying. I ain't saying nothing else about the other case.
Thank you. I understand, Mr. Hart, but what we'll do, Mr. Katz will submit that judgment to the court. I will sign it and a copy will be mailed to you on the tether issue. Follow up with who you need to follow up with, okay?
Okay.
Have a good day, sir.
Okay, thank you.
This is 2404405 LT. This is Gateway versus Christina Washington.
Yes, good morning, Your Honor. John Burncran for Gateway.
State your name, ma'am.
Christina Washington.
Ms. Washington, what's the status of your application for rental assistance?
They denied me.
And ma'am, the court did receive your comment that you need to get back to work. You've been waiting since 9:15. Your case was just scheduled at 9:15. You've had an opportunity to speak to Mr. Burncrat. Sir, how are we proceeding?
Yes, Your Honor. We've entered into a consent judgment for possession only with a deadline to pay or vacate of August 5, 2024. The amount of rent owing is $437. Court costs of $172 for a total redemption figure of $609. I've explained the 3 business day rule to her, as well as her appellate rights would also have a deadline of August 5th, 2024, and she has consented for me to sign her name to such a consent judgment.
Ms. Washington, do you have any questions about the advice of rights video that played back on July 10th, 2024?
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Mr. Burncrant's office will prepare it, file it with the court. I will sign it, and a copy will be mailed to you at the address we have on record. You have a good day at work.
You too, ma'am.
Thank you. 2404414 LT Gateway versus Jason Benson and Anaya Fletcher.
John Burncran for Gateway, and they were both represented by Wendy Cooper.
They're both represented by Wendy Cooper. Thank you.
Morning, Your Honor. Wendy Cooper, P78424 on behalf of William Banner and Marion Banner, who are also present.
I apologize. This is case 414. My mistake, Your Honor.
Thank you.
That was my mistake. We do have a default
Ms.
judgment.
Fletcher?
Yes,
State your name, please.
Anaya Fletcher.
And is Jason Benson present?
No, he's at work.
Ma'am, the last time we were here, you indicated you made an application for rental assistance. What's the status of that application?
They denied me.
Mr. Burncrant, how are we proceeding?
Your Honor, and I explained this to Ms. Fletcher. With respect to Jason Benson, we would request the entry of a default judgment for possession with a deadline of August 5, 2024 to pay or vacate. Ms. Fletcher has agreed to a consent judgment under the following terms. It would be $2,457 in rent, $214 in court costs for a total redemption figure of $2,671, again, which must be paid by no later than August 5, 2024. Otherwise, she would have to vacate the property. I've explained the 3 business day rule to her, as well as her appellate right to appeal this by August 5, 2024, and she has consented to me signing her name to such a consent judgment.
Thank you. Ms. Fletcher, you were here back on July 10, 2024, when a video played that explained the legal rights you had available. Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Were the terms of the consent judgment that Mr. Burncrant placed on the record correct? That being that you will pay a total of $2,671 or vacate the property by August 5th?
Yes.
Then he will prepare that consent judgment filed with the court. I will sign it and a copy will be mailed to you at the address we have on record. You're free to go. You have a great day.
You too.
Thank you. 24044424 LT Gateway versus Banner and Banner. Your appearances.
John Bergrant for Gateway Townhomes, Your Honor.
Good morning, Your Honor. Wendy Cooper on behalf of William Banner and Marion Banner, and I will also be filing an amended appearance on behalf of William Banner.
Thank you. Today was a day and time scheduled for the second hearing in this matter. There was an application for rental assistance as well. Ms. Cooper, how are we proceeding this morning?
Your Honor, we have reached an agreement for a consent judgment, and Mr. Bergrant, if you would put the terms on the record.
I'd be happy to. No rent involved in this consent judgment. It's a consent judgment for possession. The deadline to vacate would be July 31, 2024. If the tenants so vacate by that deadline, then Wendy and I will both sign a satisfaction of judgment, or we will set aside the judgment, one or the other.
And that's the entirety of your agreement, Mr. Bergrant?
That is, there would be the appellate date as well, which would be August 5, 2024. And of course, they're represented by counsel, so the 3 business day rule doesn't need to be explained.
Is that your understanding, Ms. Cooper?
It is, and I would also just like to ask my clients if that's their understanding as well.
Yeah, we understand.
Turn your video on for me, please, and state your names.
William and Marion Banner.
Then the court will
Banner?
await receipt of the signed consent judgment with the terms that Mr. Bergrant just placed on the record. If there's nothing else to the Banners, you're free to go. You have a great day.
Thank you, Your Honor.
Thank you. This is a recall of 2404319 LT West Village versus Kayla Johnson.
Oh,
Mr. Hitchcock, how are we proceeding?
I was supposed to talk to Renee, Your Honor.
I'm sorry?
I was supposed to talk to Renee. He told me to talk to Renee before anything. He said he's either the 5th or talk to Renee about if it's can be a little bit longer.
I'm sorry, Mr. Lee, his lips are moving, but I'm not sure. He might be in another courtroom.
Who, mine?
The attorney.
Oh, I'm sorry.
No, the issue is that you are not the tenant. You are not the named defendant. And we appeared last time the court adjourned the case over for notice to reach her. I know that when we were here on July 10th, you indicated that she was having some issues, but she is required to appear. Mr. Hitchcock, are you ready, or are you in a different courtroom, sir?
What we're about to do is, Your Honor, I was talking to Renee about it yesterday. Mrs. Samples, I was talking to her and I asked her, I was like, is there any way I can talk to Triad to switch the mortgage out to a possible name of my girlfriend and all this stuff? So we was talking about it, and I have.
Those are things
somebody that
outside
can
of these
take over.
proceedings, Your Honor. He has no standing to be here today, and I'd move for entry of default judgment against Ms. Johnson for possession only. There's rent to retain possession in the amount of $1,635.66, costs in the amount of $187.68 for a total amount of $1,823.34, which the defendant, Ms. Johnson, must pay in full or move out on or before August 5th, 2024, or the writ may issue thereafter.
Mr. Lee, the issue is that you are not a named party to this case, and when we were here before, we had a similar conversation.
Yes, ma'am.
This court has to enter a default judgment as to Ms. Johnson at this time with the amount of rent due of $1,635.66, $187.68 in court costs for a total of $1,823.34. That default judgment will indicate that that amount must be paid or the parties vacate by August the 5th. And sir, that Mr. Lee, that will conclude the matter as far as this court is concerned. That does not mean that you can't have conversation with Renee. It's just legally, unless you're an attorney, you cannot stand in and represent Ms. Johnson in this matter, okay?
Okay, I understand.
Okay. And Mr. Lee, I wish you the absolute best. You have a great day.
All right, you too. Thank you.
Thank you. Was that it for you, Mr. Hitchcock?
Yes, until 11 o'clock, Your Honor.
Thank
So-
you, sir. I'll see you in a little bit.
See you then. Bye.
2404430 OT Gateway versus Williams. Shakri,
Yes,
would you unmute state your name for me, please?
Shakri Williams.
Ms. Williams, the last time we were here, you indicated that you made an application for rental assistance. What's the status of that application, ma'am?
They denied me because I did something wrong. She called me about it, but I have to call her today. But it'll be paid if I get paid Friday. So I spoke with.
You had a chance to speak to Mr. Burnkrant, the attorney?
Yes, ma'am.
How are we proceeding, sir?
Your Honor, we have come to an agreement for a consent judgment for possession, no money judgment portion. The amount of the rent owing would be $2,504, court costs of $172, for a total redemption figure of $2,676 to be paid on or before August 5, 2024, or else she would have to vacate by that date. I've explained that she has 10 days in which to appeal this. I've pushed that to August 5, 2024. And also I've explained the 3 business day rule to come back. And she's consented to me signing her name to such a consent judgment. She does believe she can bring this current by that deadline.
Ms. Williams, was everything Mr. Burnkrant just said true and accurate?
Yes, ma'am.
And ma'am, you were here back on July 10th when the court played the video that explained the rights you had available in this landlord-tenant case. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about these proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Mr. Burnkrant's office will prepare a consent judgment with a total of $2,676 that must be paid, or you must vacate the property by August the 5th. If there's nothing else, Ms. Williams, you're free to go. You have a great day.
Thank you. You too.
Thank you, Your Honor.
Thank you, Ms. Burnkrant. 2404348 LT Maxwell versus Elijah Nelson.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Good morning.
State your name for me, sir.
Elijah Nelson.
Thank you. The last time we were here, there was a dispute as to the balance. Mr. Katz, have you had an opportunity to speak to Mr. Nelson?
I did speak with Mr. Nelson. We did enter into consent judgment, Your Honor. This is a non-payment rent possession case. There's currently a balance due of $2,927. I'm sorry, $2,757 of rent, $170 of costs for a total of $2,927. Mr. Nelson has until August 5th to pay that amount. He was advised of MCR 4.201 and did authorize me to submit this to the court with his verbal authority. I did indicate to him similarly that if he does get any permission from my client to extend that amount, that's up to my client, and I would recommend that it be in writing.
Thank you. Mr. Nelson, is everything Mr. Katz just said true and accurate, sir?
Yes, ma'am, it is.
And you were here back on July 10th when the court played the advice of rights video. Do you have any questions about the rights you have available this morning?
No, ma'am.
Do you have any questions about these proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Mr. Katz's office will prepare a consent judgment that shows a total due of $2,927 with the indication that you will pay this amount or vacate the property by August 5th. Mr. Nelson, if you have no questions, you're free to go, and that concludes this matter.
Thank you. You have a nice day.
Thank you. You too. 2404353 LT Maxwell versus Mariah Gibson.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff. Your Honor, the defendant is still in the breakout room. I have tried countless times to have her unmute. I've unmuted her device. I don't hear anything other than some crackling from her device. So I'm not sure.
Ms. Gibson? Ms. Gibson? Ma'am, state your name for me.
Oh, shoot.
Nope, ma'am, you're good.
I cannot hear you.
Let's try something else. 2404356 LT Maxwell versus Mayana White.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Have you spoken to Ms. White today?
I did not see her that she has checked in, Your Honor. I don't see her.
I was gonna say, I don't see that person's returned. We were here back on July 10th. She went in to speak to representative from Lakeshore Legal Aid.
Can y'all hear me?
Defendant
I don't know
having
what-
failed
it
to
was
appear,
working
Mr.
when I was
Katz,
on a-
how would you like to proceed?
Your Honor, this is a non-payment rent possession case. As indicated, this is a second hearing. Ms. White has failed to appear, requesting a default judgment. Currently, there's a balance due of $2,763 of past due rent, $170 of costs for a total of $2,933. Requesting a default judgment in that amount with writ to be issued after August 5th.
Please submit your default judgment.
Thank you, Your Honor.
2404347 LT Maxwell versus Donald Long.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Morning, Judge.
Good morning, sir. Have you had an opportunity to speak to Mr. Katz this morning?
We did speak, Your Honor. Mr. Long indicated that he has made a payment that is not reflected on his ledger as well. There is a check that he had indicated that he had given to my client that has not, that's been lost somehow. I did tell him that basically he needs to go to the place that he ordered that check, determine whether it was cashed, and if it's not cashed, put a stop payment on it and have them reissue a check, because my client cannot do that. It can only be done by Mr. Long. So at this point, if we can adjourn this case for 2 weeks just to make sure that Mr. Long does that. And
Get this over, Mr. Katz.
I'm sorry, what?
I'm sorry, what'd you say, Mr. Long?
Yes, ma'am. Yes, Judge. Yeah, I want to get this case over with, Judge. I can go get the money order today, and we can be up to date, and we can be done with this. Well, we don't have to keep adjourning it. I got other things to do.
Mr. Long?
Yes, ma'am.
Sir, the issue is that Mr. Katz is saying that there is money that you paid to the landlord that's not posting to the ledger. Do you want the opportunity to present proof that you have in fact tendered that money?
Oh, I got proof sitting right in front of me, Judge.
Your Honor.
Proof, not Mr. Long, not proof that you got the money, but proof that you gave it to the Maxwell, which will be a receipt or some.
Right here, Judge. Yes, right here.
What's that, sir?
This is the receipt received on 5/6/24 by the Maxwell. Miss G-I-K-E, I believe her name is.
Did you? Oh, sorry, sir. And that's part of the rent that's in dispute?
Yes, ma'am. This is the roof that's in dispute.
Well, I think Mr. Long, you might be Mr. Katz's last case with me in this time block. Mr. Katz is asking for an adjournment. Are you disputing? Are you objecting to the adjournment, Mr. Long?
No, I'm just saying, if I can go to my credit union, tell them not to cash or close out that check, and I'll get the Maxwell a new money order and they can hand it to them today. We can be done with this.
That's what Mr. Katz was asking you to do, Mr. Long.
Okay, well, I want to be done with it.
And
I don't need any more adjournments, Judge.
Well, Your Honor, just so Mr. Long understands, if we adjourn and you pay the balance today or before the 1st of the month, I dismiss the case. The adjournment is just to give you the time so I can dismiss the case.
Oh, so technically, once it gets paid, we don't need to go back on this.
Correct. It's
okay.
there just to keep the case open, but at the same time, not to give you a judgment. Okay.
Okay.
All right. Thank you, Your Honor.
So, Mr. Cash, just so we're on the same page, what is the amount of rent that's due right now?
So, Your Honor, as of today, I'm showing a balance of $2,429. However, Mr. Long indicates that he made a payment yesterday. And I'm hoping once he gets that other check paid out, that will clear out his account. So hopefully he'll be at a zero balance before the end of the month.
Is Mr. Long, you understand what Mr. Katz is saying?
Yes, ma'am, I sure do.
Then what I'll do, Mr. Long, is I'll adjourn this case over to August 6th, which is a Tuesday. It's not our regular landlord tenant date, but if you're square up with Mr. Katz and he dismisses the case, you won't need to appear on the 6th. But sir, August rent will come due and you will still be responsible for August rent.
Not a problem, Judge.
Okay.
Thank you,
Then,
Your
sir,
Honor.
I'll schedule this case for August 6th at 9 a.m. If the case is dismissed, you do not need to appear. If you have confirmed with the Maxwell that you've zeroed out the rent, you don't need to appear, okay?
Sounds fantastic.
Perfect. Thank you.
August 6th at 9 a.m. back on Zoom. Anything else, Mr. Long?
That was it, Judge. Thank you so much.
Thank you, Your Honor.
Have a good day.
All right, you too.
Thank you. We're trying to get Ms. Gibson again, 2404353LT. Ms. Gibson, are you able to hear me now, ma'am?
I unmuted it, but I can't hear nothing from y'all side.
Ms. Gibson?
The volume is all the way turned up. It worked when I'm in a breakout rooms.
Then
When I
Mr.
talk to the
Katz, let's try
clerk,
to
it
get you
was
back
working,
into a
but when I
breakout
come
room
on
with
here, it
her.
don't.
And when you come
Let
back
me
out, I'll
see.
recall it.
Okay, it didn't work when we were in the breakout room, but we'll try again.
Oh, thank you.
Thank you.
Ms. Fontanella, are we ready?
Good morning, Your Honor. I believe there are quite a few we are ready on. Ms. Kingsley's still working the breakout room, but I'm ready to go on the record on the ones that are ready if you are.
Thank you. This is 2404366LT Rawsonville Woods versus Amberlynn Bonds.
Sydney Fontanella for the plaintiff, Your Honor.
Amberlynn Bonds. Hearing no response, this case was scheduled at 10 o'clock. It's now 10:24 by this court's clock. How are we proceeding?
Your Honor, I am requesting a default judgment. There is rent to retain of $2,662.23. Court costs of $190.24 for a total of $2,852.47.
Thank you. Please submit your default judgment in that amount.
Thank you.
2404397LT Rawsonville Woods versus Destiny Walker.
Sydney Fontanella for the plaintiff.
Hi, it's Destiny Walker.
Good morning. Ms. Walker, the last time we were here, you made an indication that you filed for rental assistance. What's the status of that application for assistance?
It's still being processed. I haven't heard anything back yet.
Ms. Fontanella?
Your Honor, I don't believe that Ms. Walker has talked to Ms. Kingsley yet. Ms. Walker, did you talk to my colleague?
No, I haven't talked to anybody yet.
Okay, could
Well,
we
let's get you moved into a breakout room, ma'am. When you're done speaking with them, you'll come back out to this main session.
Okay.
Thank you, Your Honor.
Thank you. 2404460LT Holiday Woods versus Christina Cherry.
Sydney Fontanella for the plaintiff, Your Honor.
Hello.
Good morning,
Christina
ma'am. State your
Cherry.
name for me, please.
Christina Cherry.
Thank you. Ms. Cherry, the last time we were here, you indicated that you made an application for rental assistance and you filed that DC 539 with the court. What's the status of your application for assistance, ma'am?
I haven't got anything in the mail yet about it or a phone call yet.
Have you spoken to someone from Palace Law Firm this morning?
Yes, I did.
Ms. Fontanella, how are we proceeding?
Thank you, Your Honor. We did come to terms for a consent judgment. If I may go ahead and place those terms on the record.
Yes, ma'am.
There is rent to retain of $2,534.47, court costs of $190.24, for a total of $2,724.71. Ms. Cherry is going to pay that amount plus August rental charges on or before August 9th, 2024. She was advised of her rights under MCR 4.201J, and she did give us permission to sign the agreement and submit it on her behalf.
Thank you. Ms. Cherry, was that an accurate statement of the agreement you've reached with the Palace Law Firm?
Yes, I'm hoping to hear back at least by, from the front of the court.
Okay. And ma'am, on July 11th, there was a video that played that explained the legal rights you had available to you. Do you have any questions about those rights?
No,
Do you have any questions about today's proceedings?
no,
Do you have any questions about the consent judgment?
no.
Then their office will prepare a consent judgment filed electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. If there's nothing else, you have no questions, you're free to go. You have a great day.
You too, thank you.
Thank you. Ms. Gibson?
Your Honor, I was able to reach her. We spoke on the phone, so I do have her on my phone because for some reason, nothing's working on her volume. Ms. Gibson, do you hear me on the phone? Okay. Your Honor, I'm going to put this on speaker. Hopefully we can hear it all. All right.
This is 2404353 Maxwell versus Gibson. The parties have been in the breakout room. Ms. Gibson, you spoke to Lakeshore Legal Aid the last time we were here?
Yes.
Are they representing you, ma'am?
No.
Mr. Katz, how are we proceeding?
Your Honor, we did enter into consent judgment. There's currently a balance due of $1,105 of past due rent, $170 of cost for a total of $1,275. Ms. Gibson understands she has until August 5th to pay that amount. She was advised of MCR 4.201 and did authorize me to submit this to the court with her verbal authority. She did indicate she's planning on paying that amount before tomorrow.
Ms. Gibson, was that an accurate statement of the agreement that you reached with Mr. Katz?
Yes.
Ma'am, do you have any questions about the video that explained the advice, your rights available in this case? We watched that video back on July 10th, 2024.
No.
Do you have any questions about today's proceedings?
No, I just want to make sure that everything gets squared away once I make the payment.
Then ma'am, Mr. Katz's office will prepare a consent judgment that has a total of $1,275 and indicates that you will pay this amount or vacate the property by August 5th. If you have no questions, ma'am, you're free to go. You have a great day.
You as well.
Thank you, Your Honor.
Thank
And
you.
have a good day, Your Honor.
Thank you.
You too, sir. 2404362LT. This was Southwark Partners versus Kesh Cold Creations. Huh. Maybe the attorney is Fallon Moore. I'm guessing. Let's move on. 2404386LT Rawsonville Woods versus Victoria Nelson.
Sydney Fontanella for the plaintiff, Your Honor.
Oh, Ms. Nelson's still in your waiting room. Was there something else ready?
Yes, that one was ready, Your Honor. Let me see if I can pull her out. Oh, no, I'm not able to pull her out. So I do believe Robert Tackett 04494 is ready, Your Honor. Oh, I apologize. Yes, Your Honor, that one is ready.
Two 2404494 LT. Mr. Tackett, state your name for me, please, sir.
Robert Tackett.
Thank you. Sir, you had the opportunity to speak to someone from a Palace Law Firm this morning.
Yes, I did.
How are we proceeding?
Thank you, Your Honor. Sydney Fontanella for the plaintiff. We did come to terms for a consent judgment. There is rent to retain of $2,428.21, court costs of $190.24, for a total of $2,618.45. Mr. Tackett is going to pay that amount plus August rental charges on or before August 12th, 2024. We did explain to him his rights under MCR 4.201J, and he did give our office permission to sign his name to the agreement.
Mr. Tackett, was everything that Ms. Fontanella just said true and accurate?
Correct.
And sir, you were here before when the court played a video that explained the legal rights you have available in this landlord-tenant matter. Do you have any questions about those rights?
No, I did apply for the assistance. We're just waiting for a decision.
And sir, do you have any questions about today's proceedings?
No, like I said, my caseworker's working with me, so we're trying to have this resolved before the 12th.
I'm sorry, Ms. Fontanella, with the request for rental assistance pending, is there a reason why this case would not be stayed another 14 days?
Your Honor, pursuant to the court rules, it would be. I was unaware that he was still pending application.
Oh, that's what I told the last lady that I talked to.
Your Honor, yeah, I was just told that there was an agreement, so.
Oh, well, Mr. Tackett, if you have a pending application for rental assistance, this court could adjourn this case for 2 more weeks, which will put the case over till, it says August 7th, but I'm actually on a criminal docket that day. We would use August 6th. Do you want to adjourn the case over to August 6th, or do you want to enter the consent judgment?
We'll do for the 12th to make sure everything goes through.
Okay. Then, sir, Ms. Fontanella's office will prepare a consent judgment that shows that amount $2,618.45 with the indication that you will pay this amount or vacate the property by August the 12th. They will file it electronically. I will sign it and a copy will be mailed to you at the address we have on record. If you have no questions, sir, you're free to go. You have a great afternoon.
You too. Thank you so much.
Thank you. Mr. Shirky,
Yes,
have you spoken to someone from Palace Law Firm
yes, I have twice.
today?
No, once today, and then what was it? Just a couple weeks ago, I had talked to one also.
2404488 LT Holiday Woods versus Jeffrey Shirky.
Sydney Fontanella for the plaintiff.
How are we proceeding this morning, ma'am?
Your Honor, we did come to terms for a consent judgment. There is currently rent to retain of $299.27, court costs of $190.24, for a total of $489.51. Mr. Shirky is going to have this paid on or before August 5th, 2024. He was explained his rights under MCR 4.201J, and he did give our office permission to sign and submit the agreement on his behalf.
Thank you. Sir, was that an accurate statement of the agreement you reached this morning?
Yes, ma'am.
And sir, you were present back on July 11th when the video played that explained the legal rights you have available. Do you have any questions about those rights?
No, not at this time.
Do you have any questions about today's proceedings?
Yes, I do. 2 weeks ago, when I went, talked to the firm, I'm on FMLA. I get paid once a week. I told them I'm off till September. I'm trying to avoid going to court every month so I can get released to go back to work. And we agreed on $350 a week.
Mr. Shirky, is that a question
Yeah, I'm just
about the
wondering,
proceedings? Oh, okay.
I'm just asking if we're gonna go to court in August because I made arrangements prior to today, the last court date.
Sir, is it your understanding that they, okay, go ahead.
I'm just trying to avoid going to court in a couple weeks again. I talked to him 2 weeks ago. I want to make sure that agreement's done so I don't have to keep coming back for the next 2 months.
The agreement that you just placed on the record will be in writing. Ms. Fontanella's office will file it with the court. I will sign it and a copy will be mailed to you. If there is some other agreement or understanding that you have in place with Holiday Woods, I would suggest you have that in writing. Either a actual letter or email, a text or something else to confirm that you have some agreement regarding how payments will be made until you're back to work from the FMLA.
Yes, okay. I'll contact the office. Well, other than
Did you
that,
have any questions? Sorry, sir. Did you have any questions about anything else?
no, not at this time.
Then that concludes the matter, sir. You're free to go. You have a great day.
You too. Thank you. Bye.
Thank you. 2404498 LT Holiday West versus Heather Forstrom.
Oh, Your Honor.
Sydney Fontanella for the plaintiff, Your Honor.
Thank you. Ma'am, what's the status of your request for rental assistance?
I applied, I submitted, I guess, before I got the actual court judgment. So I submitted the past due bill and I guess they denied it. And I just submitted the actual court paperwork. It took her a minute to get back. I didn't understand what I was supposed to submit. I thought when I was past due, I could just submit the paperwork from the park. I didn't realize I had to submit the court paperwork. So I submitted it and I am currently waiting. Unfortunately, I've been out of work for three months now. I got really sick and then I broke my collarbone and I am trying to get back on my feet right now. And I got 2 young kids and my daughter just had a baby. So I'm just trying to get back on the, and I am ready to move if I have to. I understand that there's no way, unless they approve me, I'm not going to get caught up in the time. So I am ready to surrender the lot back if need
Ma'am,
be.
I'm sorry. Did you speak to someone from Palace Law this morning?
Yes.
Did
I
you reach
believe
an
that-
agreement with them?
Yes.
Oh, Ms. Fontanella, that agreement.
Thank you, Your Honor. There is terms for a consent judgment, Your Honor. Rent to retain is $1,563.73. Court costs of $190.24 for a total of $1,753.97. Ms. Forstrom is going to pay this plus August rental charges by August 12th, 2024. She was explained her rights under MCR 4.201J, and she did give our office permission to sign and submit this agreement on her behalf.
Ma'am, was everything the attorney just said correct?
Yes, ma'am.
And you were here back on July 11th when the video played that explained the legal rights you had available. Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No, Your Honor.
Do you have any questions about the consent judgment?
No, I do not.
Then Ms. Fontanella's office will prepare a consent judgment with the terms placed on the record. I will sign it and a copy will be mailed to you at the address we have on record. Ma'am, if there's nothing else, you're free to go. You have a great day.
Thank you, Your Honor. You too.
Thank you. 2404506 LT Holiday Woods versus Tamika Young. Ms. Young, unmute yourself. State your name for me, please.
Tamika Young.
Ms. Young, the last time that we were here, you made an application for rental assistance. What's the status of that application, ma'am?
It's still pending.
Did you speak to someone from Palace Law this morning?
I did.
Ms. Fontanella, how are we proceeding?
Thank you, Your Honor. We did come to terms for a consent judgment. There is rent to retain of $2,910.34, court costs of $190.24, for a total of $3,100.58. Ms. Young is going to pay that amount by August 12th, 2024, and she will be paying August 2024 rental charges by August 26th, 2024. She was advised of her rights under MCR 4.201J, and she did give our office permission to sign and submit the agreement on her behalf.
Ms. Fontanella, my question is the same. If Ms. Young has an application for rental assistance pending, is there a reason why this case would not be adjourned for 2 more weeks?
I believe that she did agree to the consent judgment. However, if she would prefer to adjourn it under the court rules, I believe that is also acceptable.
Ms. Young?
If that would give me more time to give them more time for my for them to, what I was trying to do was make sure that I had ample time if I didn't get the approval by the 12th. But if you can give me the time the court allows to get that approval from them, then come back, then that would be a lot more helpful.
We are able to stay the case for 14 more days, Ms. Young, but if you reach an agreement with them, it's up to you. You want that adjournment? It'll just take me a second. Let me grab a calendar, okay?
Okay.
Ms. Young, I'm looking at August the 8th, which is a Thursday. At 9 a.m.
Okay.
August the 8th at 9 a.m. If you have not received if DHS has not made a determination at that point, we'll be entering a consent judgment or having a hearing on this matter.
Okay.
We'll get notice mailed out to the parties of that new date and time. We'll be back here at this same Zoom ID, okay?
Yes, that's fine.
Anything else, Ms. Fontanella?
Nothing further, Your Honor.
Thank you, ma'am. I'll see you on August the 8th. Have a good day.
You too.
Thank you. This is 2404362LT Southbrook Partners versus Cash Coal Creations. Your appearances.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
Good morning, Your Honor. Fallon Moore, P84281 on behalf of the defendant.
Today was the day and time scheduled for the adjourned hearing in this matter. How are we proceeding?
Your Honor, it's my understanding that the defendant plans on vacating by the 1st. We're just asking for the court's next adjourn date so we can verify that happens, since it's a possession-only judgment. And if he vacates, we will submit a dismissal.
Was that your understanding, Ms. Moore?
Yes, Your Honor, that is accurate.
August 8th at 9 a.m.
Thank you, Your Honor.
Thank you. Have a great
good
day. You as well. Bye now.
Thank you. Ms. Walker, 2404397 Rossville Woods versus Destiny Walker.
Sydney
Yes.
Fontanella for the plaintiff. I don't know that Miss Walker, Your Honor, was able to actually get into the breakout room. Were you able to do?
Mm-hmm.
Did you reach an agreement with the attorney you spoke with, ma'am?
Yes.
Your Honor, I do have that agreement that I can place on the record.
Thank you.
There is rent to retain of $2,582.60, court costs of $190.24, for a total of $2,772.84. Ms. Walker is going to pay that balance on or before August 9th, 2024, and then she's going to pay the August rental charges on or before August 16th, 2024. She was explained her rights under MCR 4.201J, and she did give our office permission to sign and submit the agreement.
Ms. Walker, is everything Ms. Fontanella just placed on the record true and accurate?
Yes.
And ma'am, you were here back on July 11th when the video played that explained the legal rights you had available. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about today's proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No.
Then Ms. Fontanella's office will prepare that consent judgment, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. If there's nothing else and you have no questions, you're free to go. You have a great day.
You as well, ma'am.
Thank you. Mr. Owen, 2404517LT, Holiday West versus William Owen.
Sydney Fontanella for the plaintiff, Your Honor.
Good morning, Your Honor. William Owen.
Thank you, Mr. Owen. Have you had the opportunity to speak to someone from Palace Law Firm this morning?
Yes.
Ms. Fontanella, how are we proceeding?
Your Honor, we do have terms for a consent judgment. There is rent to retain of $927.25, court costs of $190.24, for a total of $1,117.49. Mr. Owen is going to pay that total by August 9th, 2024, and then he is going to pay August rental charges by August 23rd, 2024. He was explained his rights under MCR 4.201J, and he did give our office permission to sign and submit the agreement on his behalf.
Mr. Owen, is everything Ms. Fontanella just said true and accurate, sir?
Yes.
So, do you have any questions about the rights you have available to you this morning?
No, I've gone over them pretty extensively.
Do you have any questions about today's proceedings?
No, ma'am.
Do you have any questions about the consent judgment?
No, ma'am.
Then Ms. Fontanella's office will prepare that consent judgment, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have on record. If there's nothing else, Mr. Owen, and you have no questions, you're free to exit that room through that door to your left. The court staff will come and reset that computer, sir. Thank you.
Thank you so much. You have a great day.
You too. Thank you, sir. This is 2404670LT. This is Arfa Enterprise versus Yarborough and Dennis. Or maybe not.
Yes, ma'am. We're here.
I know, but I just lost the attorney. I'll come back to you in just a moment. This is 2404386LT. Rawsonville Woods versus Victoria Nelson. Miss Nelson, turn your video on, unmute yourself and state your name for me, please.
Okay. My video is on.
Thank you. Ma'am, the last time we were here, you indicated that you made an application for rental assistance. What's the status of the application?
So the application, the initial application that I did was Human Services. It did initially take them a long time to get back, and they said they were out of funding and sent me to St. Vincent's, and then St. Vincent's sent me to St. Anthony's in Belleville, Michigan, which at this time I haven't heard back from. So that's what happened with the whole
Ma'am, did you speak to someone from Palace Law Firm this morning?
Okay, so the lawyer that I spoke with was with my rental property. That's the only lawyer I've spoken with.
Yes, ma'am. That's Palace Law
Okay.
Firm that represents
Yes, I have.
Rawsonville Woods. Did you
Okay.
reach an agreement with them, ma'am?
Yes.
The terms of that agreement, Ms. Fontanella.
Thank you, Your Honor. There is rent to retain of $2,885.47, court costs of $190.24, for a total of $3,075.71. That balance is going to be paid on or before August 12th, 2024. And Ms. Nelson is going to pay August rental charges on or before August 26th, 2024. She was advised of her rights under MCR 4.201J, and she did give our office permission to sign and submit the agreement on her behalf.
Thank you. Ms. Nelson, was that an accurate statement of the agreement you reached this morning?
No.
No?
No, there isn't. There wasn't anything inaccurate on that.
I'm sorry?
No, there isn't anything inaccurate. No, that is correct.
Oh, okay. And ma'am, you were present back on July 11th when the video played that explained the rights you had available in this landlord-tenant case. Do you have any questions about those rights?
No, I mean, I am aware that I have 3 days to consent, I guess. But I didn't see any. I'm sorry, go ahead.
No, you go ahead.
I didn't see any video today, but
I didn't say today. I said when we were here back on July 11th.
Yeah, I honestly I don't remember, but I do know that today she said I have the 3 days to consent if I don't understand.
You don't understand?
No, she told me if I don't understand that I
Okay.
have 3 days. Yeah.
Ms. Nelson, do you have any questions about the consent judgment?
Not at this time, no.
Then Ms. Fontanella's office will prepare that consent judgment, file it electronically with the court. I will sign it and a copy will be mailed to you at the address we have. If there's nothing else and you have no questions, you're free to go. You have a great day.
You too. Thank you.
Thank you. This is 2404483LT. This is Holiday Woods versus Brian Phillips.
Sydney Fontanella for the plaintiff, Your Honor.
This case was scheduled at 10:15. It's now 10:54 by this court's clock. I don't see anyone by that name and I'm not hearing a response. How would you like to proceed?
Your Honor, I am requesting a default judgment. If I may go ahead and put the amounts on the record.
Please.
There is rent to retain of $2,696, court costs of $190.24, for a total of $2,886.24. And I would request for it to issue in 10 days.
Thank you. Please submit that default judgment. This is 2404619LT Harbor Club versus Ayana Bailey and Varun Ganapthi.
Sydney Fontanella for the plaintiff, Your Honor.
Today was the day and time scheduled for the second hearing in this matter. Ms. Bailey, please turn your video on. Unmute yourself and state your name.
Sorry, I was having a hard time unmuting it. My name is Ayana Bailey.
Thank you. Do you know where the other party is, ma'am?
He's at work. He wasn't able to get off. He travels a lot for work, so he wasn't able to take the day off for this morning. But I've been keeping him aware.
I'm sorry. The last time that we were here, you went into a breakout room with Lakeshore Legal Aid. Are they representing you this morning?
No.
Have you spoken to someone from Palace Law Firm?
No, not yet.
Oh.
Your
Let's
Honor,
get you moved into a. Go ahead, Ms. Fontanella.
I was just going to say, it was our belief that Legal Aid was representing her, but since they're not, we would love a chance to speak with her.
Okay.
Thank you. We'll get you moved into a breakout room.
Thank you.
Thank you. Mr. Rourke. This is 2404670, Arthur versus Yarborough and Dennis. May I have your appearances?
Ron Ruark, Your Honor, for the plaintiff.
This is Latrice Yarborough, and well, we're on the same room. Amaya is right next to me as well, and Shahid Dennis.
How are we proceeding this morning, sir?
I'll be glad to go into a breakout room with them, but this is the first hearing. And so I assume it's going to be an adjournment.
This is not the first hearing. The first hearing was on the 17th.
I apologize, Your Honor. Let's go into a
No
break.
worries. I thought you were already in the breakout room. We'll get you moved in there, sir. Thank you.
Thank you.
Ms. Taylor, have you spoken to someone from Palace Law Firm this morning?
You said Miss Taylor?
Yes, I sure did.
Yes, I have.
This is 2404658LT. This is Harbor Club versus Toya Taylor. Your names for the record.
Sydney Fontanelle,
Toya.
for the plaintiff, Your Honor.
Toya Taylor?
Ma'am, the last time we were here, you indicated that you made an application for rental assistance. What's the
Yes.
status of that application?
I am still waiting. I did also receive the same information that there was another person in here who applied and they stated that funding was depleted. So I'm still looking for resources and also waiting for a decision from them still. But I did talk to someone from Pallets in regards to an agreement.
Ms. Fontanella?
Thank you, Your Honor. We do have terms for an agreement, if I may put the terms on the record.
Please.
There is rent to retain of $3,249.24, court costs of $190.24, for a total of $3,439.48. Ms. Taylor is going to pay that and August rental charges on or before August 16th, 2024. She was advised of her rights under MCR 4.21J, and she did give our office permission to sign and submit the agreement on her behalf.
Thank you. Ms. Taylor, was that an accurate statement of the agreement that you reached this morning?
Yes.
And ma'am, you were present back on July the 17th when the video played that explained the legal rights you had available. Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No.
Then Ms. Fontanella's office will prepare a consent judgment with the terms just placed on the record. She will file it with the court and I will sign it. If you have no questions and there's nothing else, you're free to go. You have a great day.
Thank you too.
Thank you. This is 2404626LT. This is Harbor Club versus Jawan Davis.
Sydney Fontanelle.
Mr. Davis, sorry, ma'am. Turn your video on, mute yourself and state your name for me, sir.
Jawan Davis.
Mr. Davis, the last time we were here, you went in to speak with Lakeshore Legal Aid. Are they representing you today?
They are not.
You spoke to someone from Palace Law Firm this morning.
Yes.
How are we proceeding, ma'am?
Thank you, Your Honor. We did come to terms for a consent judgment. There is rent to retain of $2,130, court costs of $190.24, for a total of $2,320.24. Mr. Davis is going to have this paid on or before August 5th, 2024. He was advised of his rights under MCR 4.201J, and he did give our office permission to sign and submit this agreement on his behalf.
Thank you. Sir, was that an accurate statement of your agreement?
Yes, I do have a question or request, if I may.
Let me ask you a few more questions and then you'll ask your question, okay?
Okay.
Thank you. You were here back on July 17th when the court played the video that explained the legal rights you had available this morning. Did you have any questions about those rights?
No.
Do you have any questions about the consent judgment?
Yes.
What was your question, sir?
If I could possibly move the date to the 8th or the 9th to match up more with my pay period, so I know for sure that everything is in place.
From the 5th to the 8th?
Yes.
Ms. Fontanella, do you have authority from your client to allow to the 8th of August?
Your Honor, I do not have. I could do it if we could include August rental charges. Would you be able to do that, Mr. Davis?
If it includes what?
I would be able to give you until the 9th if it would include August rental charges as well. Are you going to be able to do that?
Yes, I'd be able to do that.
Okay, then if I would be fine to put the record straight that we have an agreement for the amount $2,320.24 plus August 2024 rental charges to be paid on or before August 9th, 2024, Your Honor.
Anything else, Mr. Davis?
No, ma'am.
Then Ms. Fontanel's office will prepare a consent judgment with the terms placed on the record. The court will sign it and a copy will be mailed to you at the address we have. If there's nothing else, you're free to go. You have a good day.
Thank you, you too.
Thank you. Two 40459 LT Westlake versus Isaac Graham.
Good morning, Your Honor. Ryan Wojcik, P84535 on behalf of the plaintiff. Good to see you.
Good to see you, sir. Mr. Graham, if you would unmute yourself and turn your video on, state your name for me.
Okay, Isaac Graham. Give me 1 second to turn my video on. Okay, here I am. Isaac Graham.
Thank you. Mr. Graham, the last time we were here, there was a payment outstanding between Westlake and yourself. Have we since resolved that payment or confirmed that payment, Mr. Wojcik?
Yes, Your Honor, the parties have agreed to enter into a resolution for the remaining balance.
And that would be?
It's consent judgment of possession only. Parties agree the rent to retain is $1,145.50, cost of $181.04, for a total to be paid of $1,326.54. That is the balance through July. Defendant can get that caught up by a writ date of August 5th, 2024. I did advise the defendant of his MCR 4.201J rights, have his permission to sign his name to a consent judgment to that effect, which we will e-file with the court.
Thank you. Mr. Graham, was that an accurate statement of your agreement?
Yes, it is.
And you were here back on July 17th when the video played that explained the legal rights you had available. Do you have any questions about those rights?
No, ma'am.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No, I don't.
Then their office will prepare a consent judgment, file electronically with the court. So long as the numbers on that document match what were just placed on the record, I will sign it. And a copy will be mailed to you at the address we have on the record. If you have no questions, you're free to go. You have a great day.
All right, you do the same. Thank you.
Thank you.
Thank you. 2404650 LT Harbor Club versus Jay Reddy.
Sydney Fontanella for the plaintiff, Your Honor.
I don't believe that that person has checked in this morning. That case was scheduled at 10:30. It's now 11:05 by this court's clock. How would you like to proceed?
Your Honor, I am requesting a default judgment if I may go ahead and put the amounts on the record.
Yes, please.
There is rent to retain of $2,717.87, court costs of $190.24, for a total of $2,908.11. And I would request for it to issue on or after August 5th, 2024.
Thank you. Please submit your default judgment through OnBase 2404652 Harbor Club versus Lindsay Ronald and Teresa Ronald.
Sydney Fontanella for the plaintiff.
Hi, Lindsay Ronald here.
Yes.
I'm trying to get my video to work. There we go.
Thank you. Ms. Fontanella, how are we proceeding?
Your Honor, we did come to terms for an agreement. There is terms for a conditional dismissal. Miss Lindsay Ronald is going to pay the amount of rent to retain of $2,429.46, court costs of $248.83, for a total of $2,678.29 on or before August 5th, 2024. The same terms would apply to Miss Teresa Ronald, as she's not here to consent. And we did explain to Miss Ronald her rights under MCR 4.201J, and she did give our office permission to sign and submit the conditional dismissal on her behalf.
I'm sorry, Ms. Fontanella, that pay by date was?
August 5th.
5th, thank you. Ms. Ronald, was that an accurate statement of the agreement you reached this morning?
Yes, it was.
And you were here back on July 17th when the video played that explained your rights in this case. Do you have any questions about those rights?
Nope.
Do you have any questions about today's proceedings?
Nope.
Do you have any questions about the conditional dismissal?
I think my video's breaking up.
I'm sorry?
Still there? I think it
Did
was
you have any
breaking up
questions
a
about?
little.
Oh, do you have any questions about the conditional dismissal?
No.
Then Ms. Fontanella's office will prepare it, file it electronically with the court. As long as what she files matches what was just placed on the record, I will sign it. And a copy will be mailed to you at the address we have. If there's nothing else and you have no questions, you're free to go. You have a great day.
Thank you. You too, Your Honor.
Thank you. This is This is 2404596 LT Westlake versus Jessica Pajay.
Good morning again, Your Honor. Ryan Wojcik, P84535 for the plaintiff.
Jessica Pajay.
Thank you. Ma'am, the last time we were here, you went into a breakout room with Lakeshore Legal Aid. Are they representing you this morning?
No.
You've had an opportunity to speak to the representative from Westlake. Were you able to reach an agreement this morning?
Yes.
How are we proceeding?
Your Honor, I did have a chance to discuss with Ms. Pajay. The parties have agreed to enter into a conditional dismissal on this one. It will be possession only. Defendant shall pay rent to retain $2,899.04, cost of $181.04 for a total of $3,080.08. Shall either pay that amount or vacate by August 5th, 2024. The defendant's intention is to vacate. So we did put in further conditions. Defendant shall pay the amount due in 2D above or vacate by August 5th, 2024, or an immediate judgment and writ may issue pursuant to 4B below. So we would have 4B checked in there that there would not be a further court date. Partial payment would not prevent eviction. I did advise the defendant of her MCR 4.201J rights and have permission to sign her name to a consent judgment to that effect. I'm sorry, a conditional dismissal to that effect, which we will submit to the court.
And was that an accurate statement of the agreement you reached this morning?
Yes.
And you were here back on July 17th when the court played the video that explained the rights you had available. Did you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No.
Do you have any questions about the conditional dismissal?
No.
Then he will file that electronically with the court. As long as what's filed matches what was just placed on the record, I will sign it. And a copy will be mailed to you at the address we have on record. If there's nothing else and you have no questions, you're free to go. You have a great day.
Thank you. You as well.
Thank you.
Thank you. This is 2404619 LT Harbor Club versus Bailey. Miss Bailey, I am so sorry. I saw you come back in.
Sydney Fontanelle for the plaintiff.
I'm sorry. I'm here.
No,
I'm
you're
sorry. I have a
you're
newborn. I'm
fine,
trying to
ma'am. I
get
saw
him to
you
stop
pop back
crying.
in. It took me a minute to get back to you. How are we proceeding, Miss Fontanella?
Your Honor, we did come to terms for an agreement. Miss Bailey is going to, or rent to retain is $2,462. Court costs of $248.83 for a total of $2,710.83 to be paid on or before August 7th, 2024. This is a consent as to Miss Bailey, and the same terms would apply to Mr. Ganapathy. He would be here to consent to that. She was advised her rights under MCR 4.201J, and she did give our office permission to sign this agreement and submit to the court as well.
Ma'am, was that an accurate statement of the agreement you reached this morning?
Yes.
And you were here back on July 17th when the court played the video that explained the legal rights you had available. Did you have any questions about those rights?
No, not at this moment.
Did you have any questions about today's proceedings?
No.
Do you have any questions about the consent judgment?
No, ma'am.
Then Ms. Fontanella's office will prepare a consent judgment with the terms just placed on the record. She will file it electronically with the court. As long as what she files matches what was just placed on the record, the court will sign it, and a copy will be mailed to you at the address we have. If there's nothing else and you have no questions, you're free to go. You have a great day.
Thank you. You guys as well.
Thank you. 2404660 LT Harbor Club versus Natasha Valenti.
Sydney Fontanella for the plaintiff.
This case was scheduled at 10:45 this morning. It's now at 11:12 by this court's clock. This was the day and time scheduled for the second hearing. I'm not hearing a response from Ms. Valenti. How would you like to proceed?
Your Honor, I am requesting a default judgment if I may put the amounts on the record.
Yes, please.
There is rent to retain of $1,591. Court costs of I'm sorry, Your Honor, could you pass on this? My math is off. I'm so sorry.
Absolutely, no worries.
Thank you.
2404670 LT Arfa versus Yarborough and Dennis. The parties have been in the breakout room. Mr. Ruark, how are we proceeding?
Your Honor, I'm not sure if this is the right case. It's Arfa Enterprises.
That's the case it just called.
Okay.
Yes, sir.
All right, I misunderstood. I think we have a consent judgment of possession only, Your Honor. The terms would be that the rent to retain possession is $6,000, $190 in costs and so on. For a total judgment of possession only, $6,190. They'd have until August the 5th to pay that amount or vacate, their choice. And I have explained to them the 3-day rule. I think they understand that, but if the court wants to reaffirm it, that's fine with me. And I believe I have.
I'm sorry, go ahead, sir.
I believe I have their permission to sign their names to the consent judgment of possession only.
Thank you. So when we were here back on July 17th, the tenants indicated that they made application for rental assistance. What's the status of that application?
We talked about that, Your Honor. Maybe Latrice could explain that to you.
I'm waiting for one of them to unmute and tell me what happened with the application.
It was a different, I'm sorry, it was a different amount on there, and my worker said she needed someone with the accurate amount on there in order for us to be able to move forward.
So they wanted you to return with the judgment?
She wanted me to have an accurate amount because the paperwork that I had gave her had 2 different amounts on it.
Now, Your Honor, the amount we're talking about basically is a compromise amount for possession only.
Yeah.
My client believes that the accurate amount is higher than that. But we have a bit of a lower amount.
So that wasn't, what Mr. Roark just indicated on the record, $6,190 paid or vacate by August the 5th was an accurate statement of the agreement you reached with him this morning?
Yes, ma'am.
And you were present back on July 17th when the video played that explained the legal rights you have. Do you have any questions about your rights, ma'am?
No, ma'am.
Ms. Dennis, do you have any questions about your rights this morning?
It's Mr. Dennis, I'm sorry.
No, ma'am.
I'm sorry, Mr. Dennis, sorry. And to the other, Ms. Yarborough, any questions about your rights?
No, ma'am.
Do you have any questions about the consent judgment? Mr.
No, ma'am.
Dennis?
No, ma'am.
Ms. Yarborough?
No, ma'am.
Ms. Yarborough?
No, ma'am.
Then Mr. Ruark will prepare a consent judgment with the terms just placed on the record. He'll file that electronically with the court as long as what he files matches what was just placed on the record. The court will sign it and a copy will be mailed to you at the address we have on record. If there's nothing else, you're free to go. You have a great day.
Thank you.
Thank you, Your Honor.
Thank you. 2404675 LT Belleville Point versus Jonathan Ford and Lexus Harrison.
Good morning, Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Thank you. Ms. Harrison, state your name for me, please.
Lexus Harrison.
Do you know where Mr. Ford is?
He's right here.
Oh, state your name, sir.
Jonathan Ford.
Thank you. The last time we were here, you went in to speak with Lakeshore Legal Aid. Is Lakeshore Legal Aid representing you today?
Oh, no.
You have the opportunity to speak to Ms. Cohen?
Yes.
How are we proceeding, ma'am?
We entered into a consent judgment, which I could put on the record, Your Honor.
Yes, please.
Okay, we've entered into a consent judgment whereby Ms. Harrison and Mr. Ford have agreed that there's a total of $1,776 owed in rent, $188.93 in court costs, for a total of $1,964.93. And they have agreed to pay those amounts by August 5th, 2024, and are aware that a writ could issue thereafter if those amounts are not paid.
Thank you. Ms. Harrison and Mr. Ford, you were present back on July 17th when the court played the video that explained the legal rights you have available today. Do you have any questions about those rights?
No.
Sir,
No.
do you have any questions about today's proceedings?
No.
No.
Do you have any questions about the consent judgment?
No.
No.
Then Ms. Cohen's office will prepare a consent judgment with the terms just placed on the record. So long as what she submits to the court matches what was just placed on the record, the court will sign the consent judgment, mail copies to you at the address we have on record. If there are no questions and you have nothing else, you're free to go. You have a great day.
Yeah, they did give me permission to sign their name and electronically submit it to the court.
You're saying that they did, or you're asking them to?
No, they did when we were in the breakout room. So I'm gonna go ahead and do that, right?
Ms. Harrison, that was your understanding?
Yes.
Thank you, Ms. Cohen. Please do that.
Okay, thank you so much. Have a wonderful day.
You too, thank you. 2404608 LT Southport versus Pride and Stanford.
Good morning again, Your Honor. Ryan
Oh,
Woodrick.
wait. What happened? Mr. Wojcik, this is the same thing that happened last time. I saw Ms. Pride check in.
I did as well.
But she's not here now. The case was scheduled at 11 o'clock. It's now 11:19. How would you like to proceed?
Your Honor, we are requesting a judgment by default. Rent to retain in this matter based on the books and records of my client of $2,229.80. Cost of $230.43 for a total of $2,460.23. We are requesting a writ date of August 5th, 2024. This would be possession only, no money judgment shall enter, and we will e-file a copy of that proposed judgment with the court.
Thank you, sir.
Thank you very much.
And that's it for you this morning?
That is it for me. Have a great rest of your week.
You too, thank you.
Thank you.
2404664 LT Harper Club versus Lloyd Wilson.
Sydney Fontanella for the plaintiff. Your Honor,
He looks like he's still in with your office.
Yep, thank you. And I'm ready on the other one that I needed to redo the math on, whenever you are.
2404660 LT Harbor Club versus Valente.
Sydney Fontanella for the plaintiff, Your Honor.
Defendant still has not appeared. How would you like to proceed?
Your Honor, I am requesting a default judgment. There is rent to retain of $1,591, court costs of $190.24, for a total of $1,781.24. And I would request for it to issue in 10 days.
Thank you. Please submit your default judgment.
Thank you.
This is 2404614 LT. This is Park Estates versus Elizabeth Sevilla.
Good morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine on behalf of Park Estates.
Mr. Hitchcock, this case was scheduled at 11 o'clock. It's now 11:21 by my court clock. The defendant having failed to appear for this requested hearing, how would you like to proceed?
Your Honor, plaintiff moves for entry of a default judgment of possession only. There's rent to retain possession in the amount of $2,309.49, costs in the amount of $187.68, for a total amount of $2,497.17, which the defendant must pay in full or move out on or before August 5th, 2024, or the writ may issue thereafter.
Thank you, Mr. Hitchcock. Please submit your default judgment.
Yes, I will. Thank you, Your Honor, very much. You have a nice day.
You too, thank you. This is 2404677 LT MSR Holding versus Raymond Jackson.
Good morning, Your Honor. Afan
morning, Your
Bapeka
Honor.
on behalf of MSR Holding LLC.
Good morning.
Raymond
Your name
Jackson,
for the
Your Honor.
record, sir?
Raymond
Thank you,
Jackson.
Mr. Jackson. The last time we were here, you indicated that you made an application for rental assistance. What's the status of the application, sir?
I checked it today. It still haven't gave me a decision. I submitted all the paperwork that I had to with the court too.
Mr. Bapaka, how are we proceeding?
Your Honor, we did work out a consent. I went over all the balances outstanding with Mr. Jackson, and we're
I'm
prepared.
sorry, with you reached an agreement, although his application for rental assistance is outstanding?
Yes, Your Honor, and we feel that the entry would allow for to expedite the process.
Was that your understanding and agreement, Mr. Jackson?
Well, it was an agreement I really didn't understand. I thought, you know, since I had an application out there pending.
Sir, the court's understanding of the matter is if there's an application that remains pending, and this case has only been adjourned from the 17th to today, that Mr. Jackson would be entitled to an additional adjournment. Was that not your understanding of the court rule?
Your Honor, my understanding is that we have to have written confirmation. It has to be submitted within 5 days of the last hearing. I don't think that was ever done. At least I didn't receive it.
Oh, Mr. Jackson, did you submit that DC 539 with the court?
Yes, I sent it to that civil email address that they sent the form to me from.
Oh, let's double check that.
Yeah, if it was sent to the court and the court acknowledges receipt, then that's fine, Your Honor.
I didn't see it when I looked on Monday, but Monday was a long time ago. Mr. DePacker filed it, I'm sorry, Mr. Jackson filed it within the 5 days indicated by the court. That being the case, Mr. Jackson, the court will adjourn this case over till August the 8th at 9 a.m. I'm sorry, 9:15. 9:15 a.m. And if you don't have a decision, there will be no further adjournments and the court would entertain the consent judgment.
Okay, thank you, Your Honor.
Okay, you said the 8th?
The 8th at 9:15, back on the same Zoom ID. Court staff will mail you notice of that new date and time, sir.
Okay, I appreciate that.
Thank you.
Your Honor.
Have a
Thank you,
good
Mr.
day.
Jackson. We'll talk to you
Thank
then.
you.
Have a good one.
Oh, let's get going with Mr. Wilson. It's our last case, Dan. I don't know how that happened.
I believe that was an 11 o'clock case, Your Honor, so maybe that's how it happened, but hopefully we'll be done soon.
We're almost there, Judge.
I know. It's fine. And I've even managed to put some notes in for you.
Well, thank you. You're always quick.
Because otherwise I'll lose my paper or I'll forget what the cryptic notes mean.
I understand that.
This is 244664 LT Harbor Club versus Lloyd Wilson. Mr. Wilson, please turn your video on. State your name for me, sir.
Lloyd Wilson.
Thank you. You've had the opportunity to speak to a representative from Palace Law Firm.
Yes, Your Honor.
How are we proceeding this morning?
Thank you, Your Honor. There was terms for a consent judgment. There's rent to retain of $80, court costs of $190.24, for a total of $270.24 to be paid on or before August 5th, 2024. Mr. Wilson was explained his rights under MCR 4.201J, and he did give our office permission to sign and submit the agreement on his behalf.
Mr. Wilson, was that your understanding?
Yes.
And sir, you appeared back on July 17th when the video played that explained the rights you had available in this landlord-tenant case. Do you have any questions about those rights?
No.
Do you have any questions about today's proceedings?
No, Your Honor.
Do you have any questions about the consent judgment?
None.
Then the law firm will prepare a consent judgment with the terms just placed on the record. They will file it electronically with the court. As long as what they file matches what was just placed on the record, I will sign it and a copy will be mailed to you at the address we have. If there's nothing else and you have no other questions, sir, you're free to go. You have a great day.
Thank you. You too.
Thank you, sir.
Thank you, Your Honor. I believe that resolves our cases today.
That does. Thank you so much. Have a good afternoon.
You too,
Thank
Your
you, Your Honor.